Imagine you've got this incredible idea, maybe a side hustle, or you and a few friends are ready to launch a passion project. You've probably heard about companies and all their complexities, and you might think, gosh, there has to be a simpler way for a small business to get started, right?
Well, for many years in South Africa, there absolutely was. And that's what we're diving into today.
Exactly. We're taking a deep dive into the South African Closed Corporations Act, number 69 of 1984. Our mission really is to demystify this key piece of legislation. We want to explore why it was created, its main features, and, how it shaped the business landscape for a certain kind of entrepreneur.
Right. And what's really interesting, I think, is we're not just looking at what a closed corporation or CC is, but why it mattered so much. We'll get into the practical side, how it allowed for simpler operations, but still gave that crucial limited liability. And maybe most importantly, when that protection could actually disappear.
Yeah, that bit's crucial. So for you listening, whether you're just curious about business structures, maybe thinking of starting something, or you're an aspiring legal eagle, this should be a good shortcut to understanding a pretty unique legal entity. This act, it was signed into law back in June 1984, kicked off officially on January 1st, 1985. So it really captures a specific approach to small business from that era.
It does. And here's a vital point to grasp right away. While this Closed Corporations Act is still active for all the existing CCs out there, it was updated as recently as 2011, and its rules are still checked and applied. You actually can't form new closed corporations anymore.
Yeah.
That door closed when the New Companies Act of 2008 fully came into play.
Right, so it's like a closed chapter for new entrants, but still very much the operating manual for thousands of existing businesses.
Exactly, a living piece of legal history, in a way.
Okay, so let's unpack it. What exactly was a closed corporation at its heart? How did the Act define it?
Well, fundamentally, the Act provided the whole framework. It covered everything from how you form and register a CC, how it becomes its own legal entity, right through to management control, and even eventually how it gets wound up. It was specifically designed, to be a simpler, more accessible alternative to a full-blown company, really aimed at smaller operations.
That makes total sense. So it was about creating a business structure that wasn't tangled up in all the red tape of a big company, but still offered those key advantages. And one of the biggest advantages has to be what lawyers call juristic personality, right?
That's spot on. Section 2, subsection 2 of the Act is key here. Upon registration, a CC became a juristic person. Think of it like the business putting on its own legal identity. It steps into the legal world as its own entity, totally separate from its owners, the members.
So the CC itself can own property, take out loans.
Yes, exactly. It can own assets, incur debts, sue someone, or be sued, all in its own name, distinct from the individuals who actually own shares, or rather, interest in it.
Which leads us to the big one, limited liability. So if the business runs into financial trouble, my personal assets, my house, my car, they're generally safe. That's the idea.
Precisely. Section 2, subsection 3 made that clear. Members are not automatically liable for the corporation's debts just because they are members. This was huge for entrepreneurs. It created this protective shield around their personal wealth, insulating it from business debts, provided everything was done properly.
Okay, and it also had perpetual succession. What did that mean in practice for a CC?
It means the CC keeps existing even if the members change. So if a member sells their interest, leaves, or even passes away, the CC, as a legal entity, continues. It doesn't just dissolve like, say, a simple partnership might when a partner leaves.
Right. That gives it stability, longevity. You can plan long-term without worrying that one member leaving sinks the whole ship.
Exactly. That continuity is incredibly valuable for a business.
Okay, a powerful mix for small businesses. But who could actually be a member? I remember there was a limit and rules about who could join.
You're right. The law was very specific. First, there was a cap. No more than 10 members in a single CC.
Only 10, okay.
And here's a major difference from companies. Section 29 said only natural persons, so real living human beings, could be members.
So no other companies holding shares, no trusts, just people.
Generally, yes, just people. But the Act did carve out some specific and quite important exceptions, mostly around trusts, actually.
Oh, okay. Like what?
Well, for instance, a person, whether natural or juristic, could act as a trustee for a testamentary trust. That's a trust set up in someone's will after they die and hold a member's interest for that trust.
Okay, so if a member died and left their interest in a trust via their will.
Correct. And similarly, a legal representative, like an executor of an estate or a curator for someone incapacitated, could hold the interest. It was about ensuring the interest could still be managed if the original member couldn't.
That handles death or incapacity. But what about trusts set up while someone's alive, inter vivos trusts? Could they hold an interest?
That was trickier. A trustee of an inter vivos trust could potentially be a member, but under very strict conditions laid out in Section 29(1)(a). The rules were there to make sure these trusts didn't become a backdoor way to bypass the natural person's only rule or the 10-member limit.
What kind of conditions?
For example, no juristic person, like another company, could be a beneficiary of that trust. The trustee themselves was personally liable for the CC's debts, just like any other member. And crucially, if you added up the number of beneficiaries of that trust, plus the other members of the CC, and the total went over 10, then that trust couldn't be a member anymore. The exemption was lost.
Wow, okay. So they really wanted to keep these things small and personal.
That was definitely the intention. Keep it simple, keep it contained.
Right. So you figured out who can be a member. What was the first practical step to actually forming a CC, the key document?
That key document was the founding statement, governed by Section 12. Think of it as the CC's constitution or birth certificate, all rolled into one. It had to be signed by every single initial member.
And what crucial info had to be in this founding statement?
It was pretty detailed. You needed the full name, obviously, and it had to end with the letters CC, or the equivalent abbreviation in another official language. That was mandatory. The main type of business the CC planned to do, the postal address and the physical address of its registered office for each member, their full name, ID number, or date of birth if no ID, and their home address for each member. Crucially, the size of each member's interest always is a percentage. This determined voting power and profit share for each member. Details about what each member initially contributed, was it cash, property, maybe services rendered to get the CC started, and the fair value of that contribution for each member. And finally, the name and postal address of the person appointed as the accounting officer, plus the date of the CC's financial year end.
Okay, quite a checklist. Once you had that statement drafted and signed, what was next? Lodging it somewhere.
Exactly. You'd lodge the founding statement, Form CK1 it was called, with the registrar. Nowadays, that function sits with the Companies and Intellectual Property Commission, or CIPC, the Act calls it the commission. You paid the fee, and assuming everything was in order and the business was lawful, they'd register it.
And then official recognition?
Yes. The registrar would assign a unique registration number and issue a certificate of incorporation, Form CK2. And that certificate was powerful. Section 14 said it was conclusive evidence that the CC was properly incorporated according to the Act. Your business was officially born.
Okay, so the CC is up and running. Let's talk about managing it day to day. How did the Act ensure things like transparency and keeping records straight for these, simpler entities?
Oh, transparency was built in to some extent. The Commission, the CIPC, keeps registers of all CCs, and Section 5 stated that generally anyone could inspect the documents held by the Commission or get certified copies, usually by paying a fee. And the Act even anticipated the digital age, allowing for electronic filing and access for many things.
Right. And what if things changed inside the CC? New address, new member joins. Did you have to tell the Commission?
Oh, absolutely. That was critical. Section 15 demanded that if any information in the original founding statement changed member details, addresses, contributions, business scope, even the accounting officer of the CC had to lodge an amended founding statement, Form CK2 again, within 28 days of the change.
28 days. And what if you didn't?
There were penalties. The Act allowed for fines for each day of noncompliance, and these could eventually be treated as a civil debt owed by the members themselves. So there's a real stick to ensure timely updates. Keeping that public record accurate was important.
And wasn't there a yearly check-in required as well?
Yes, under Section 15A, the annual return. Every year, the CC had to submit this return to the Commission, basically confirming that all its registered details were still correct, or updating them if needed and paying the annual fee. It helped keep the register clean and current.
Makes sense. And we mentioned the name earlier, the mandatory CC at the end.
Correct. Section 22 was clear. The abbreviation CC, or its equivalent, must form part of the name used by the corporation. And Section 22A made it an offense for any person or business not registered as a CC to use that abbreviation or pretend they were one. That protected the public from being misled.
Okay, that covers the sort of external admin and public face. What about the internal dynamics? How did members sort out how they'd work together and make decisions?
That's where the association agreement came in, covered by Section 44. This wasn't mandatory, but for any CC with more than one member, it was highly advisable. It was a written agreement signed by all the members that could regulate pretty much any aspect of their internal relationship, how decisions are made, profit distribution, exit strategies, you name it. As long as they didn't contradict the act itself, it gave them huge flexibility to customize their own rules.
So it's like their internal partnership agreement tailored to their specific needs, and it binds new members too.
Yes. Once agreed, it bound all existing and any future members who joined later. It provided that internal rulebook.
But if I'm an outsider, let's say a supplier dealing with the CC, I wouldn't know what's in their private association agreement, right? I wouldn't be expected to.
No, absolutely not. Section 45 specifically protected outsiders. It said third parties weren't deemed to have knowledge of the contents of an association agreement just because it exists or is filed. You deal with the CC based on the public documents and the act, not their private internal arrangements.
That seems fair. Now, a really fundamental part of any business structure is the trust and responsibility between the owners. What about the duties members owed to the CC itself, the fiduciary duties?
Yes, Section 42. This is critical. It's stated very clearly, each member shall stand in a fiduciary relationship to the corporation. In simple terms, this means members had a legal duty to act honestly, in good faith, and always in the best interests of the CC as a whole. They had to put the corporation's interests ahead of their own personal interests.
So no self-dealing or secret profits.
Exactly. Section 42.2 spelled out specific duties, like acting honestly and for the CC's benefit, avoiding conflicts between their personal interests and the CC's interests, for instance, not taking personal advantage of corporate opportunities or contracts without full disclosure and approval. They also generally couldn't compete directly with the CC's business.
And if they breached these duties, if they put their hand in the cookie jar,
then they were personally liable to the CC for any loss it suffered as a result or for any personal economic benefit they gained because of the breach. The CC could legally recover that money from the member.
Okay, that covers honesty and good faith. What about just competence? If a member makes a genuinely bad business decision, not dishonest, just clumsy, that hurts the CC.
That was covered too under Section 43. Members could be held liable for losses caused by their failure to act with the degree of care and skill that may reasonably be expected from a person of his or her knowledge and experience.
Yeah.
So it wasn't an impossibly high standard, but you were expected to use reasonable care and the skills you actually possess when managing the CC's affairs. You couldn't just be negligent without potential consequences.
Right. So there's a baseline expectation of competence. Now, what if members didn't have an association agreement, or maybe their agreement was silent on certain things? How did decisions get made then? Were there default rules?
Yes, Section 46 provided the default playbook, often called the variable rules. If the association agreement didn't specify otherwise, these rules applied. For example, the default was that every member was entitled to participate in carrying on the business. Management rights were generally equal, but, and this is a big but for certain major decisions, you needed the written consent of members holding at least 75% of the total members' interest.
75%. Wow. What kind of decisions needed that supermajority?
Things like changing the main line of business, selling off a major part of the business or its assets, or any transaction involving buying or selling immovable property, like land or buildings.
So a member holding just over 25% could effectively veto those huge decisions. That's significant power, even for a minority holder in some cases.
It certainly could be. Other default rules included settling disagreements by a simple majority vote, where votes are based on percentage interest, the CC having to reimburse members for legitimate business expenses, and payments to members, like profit distributions, being proportional to their percentage interests, unless they agreed otherwise.
So clarity on how to run things, even without a custom agreement. Were there any people specifically barred from managing a CC?
Yes. Section 47 listed disqualified persons. This included, for example, anyone under a legal disability, like being declared mentally unfit, though there was a minor exception, anyone who's an unrehabilitated insolvent, or anyone who'd been removed from an office of trust for misconduct, or disqualified from being a company director. It was about protecting the CC from potentially harmful management.
Okay, that makes sense for maintaining integrity. Let's shift gears slightly to the financials. Record keeping and reporting, how strict was it for a CC?
It was still pretty rigorous, actually. Section 56 required every CC to keep proper accounting records in at least one official South African language. These records had to accurately show the CC's transactions, its financial position, covering assets, liabilities, member contributions, loans in and out, cash flow, credit sales, stock, everything needed to give a fair picture. And they had to be kept properly, safe from tampering or falsification.
And then the annual summary, the financial statement.
Yes. Under Section 58, within 6 months after each financial year end, the CC had to prepare annual financial statements. These typically included a balance sheet showing assets and liabilities and an income statement showing profit or loss. Critically, these statements had to conform to, quote, generally accepted accounting practice, appropriate for the CC's business, fairly present in its financial state, and importantly be formally approved and signed off by members holding at least 51% of the total interest.
51% approval. Okay. Now, we touched on the accounting officer earlier. This sounds like a really key role, especially for ensuring financial accountability in this simpler structure. Can you elaborate on their function?
You're absolutely right. The accounting officer was a cornerstone of the CC framework. Section 59 mandated that every CC must appoint one and ensure the position stays filled. Their qualifications, set out in Section 60, were quite strict. They couldn't just be anyone. They had to be a member of a recognized professional body, like SECA or SEP, the accounting bodies, which means they'd passed relevant exams in accounting and corporate law and were subject to a professional code of conduct. This ensured a certain level of expertise and independence.
So a qualified professional overseeing the books, what were their specific duties according to the Act?
Section 62 laid out their core duties. Within 3 months of appointment, they had to confirm the CC had a proper financial year-end and was maintaining adequate records. Annually, they had specific reporting duties. They had to review the annual financial statements to ensure they agreed with the underlying accounting records. They also had to assess whether the accounting policies used by the CC were appropriate for its business.
Okay, so a check on accuracy and policy. But you mentioned earlier they had a reporting duty to the registrar.
Yes, and this is where the accounting officer acted as a crucial watchdog. If, in performing their duties, the accounting officer discovered that the financial statements were incorrect in a material way, or that the CC had failed to comply with key provisions of the Act, like keeping proper records or restrictions on loans, they had to report it. Even more significantly, if they found reason to believe that the CC's liabilities exceeded its assets or that it wasn't actually conducting business operations anymore, they were obligated to report this in writing to the Commission, CIPC, immediately.
Wow. So they weren't just checking the math. They were actively looking for signs of financial distress or serious noncompliance and had a duty to flag it to the authorities.
Exactly. It was a critical safeguard intended to provide an early warning if a CC was heading for trouble or potentially breaking the rules, offering some protection to creditors and the public interest.
That's a really powerful mechanism. Which brings us neatly to the next big question. We've hyped the limited liability benefit, but you hinted it wasn't bulletproof. When could things go wrong? When could members actually lose that protection and find themselves personally liable? When was the veil lifted?
Right. This is the aha moment, as you called it earlier, and it's vital for anyone who ever dealt with a CC or owns one to understand. Limited liability was the general rule, but Section 63 carved out specific exceptions where members, and sometimes others, could face joint and several liability for the CC's debts, meaning creditors could pursue them personally.
Okay, let's break those down. Give us the main examples where that shield could just vanish.
Sure. Here are some key ones from Section 63. Forgetting the CC. If the corporation's name was used on, say, a contract or order form without the mandatory CC abbreviation, and the other party didn't know they were dealing with the CC, any member responsible for that omission or who authorized it could be personally liable for any debt arising from that specific transaction. A simple but potentially costly mistake.
Ouch. So attention to detail and paperwork was critical. What else?
Unpaid contributions. If a member promised to contribute money or property when the CC was formed, as listed in the founding statement, but failed to actually pay it over, that member was personally liable for all the CC's debts incurred from the date of registration up until the day they finally made that contribution.
So you couldn't just promise assets and not deliver?
Nope. Another big one. Illegal membership. If a juristic person, like a company or a trustee, held a member's interest in violation of the rules we discussed earlier, like the trust exceeding the 10-person limit, that juristic person or trustee and any member aware of the contravention could be held personally liable for the CC's debts during the period the illegal holding continued.
Okay, so violating the membership rules had teeth. Any others related to financial dealings?
Yes. Improper financial assistance. If the CC improperly paid for acquiring a member's interest, Section 39, or gave financial help for someone else to buy a member's interest, Section 40, breaking the solvency and liquidity rules, then any member aware of it and the person who received the payment assistance could be liable for debts existing before that transaction happened.
So taking money out improperly could backfire personally.
Definitely. Also, disqualified management. If someone acted in management while they were disqualified under Section 47, like an unrehabilitated insolvent, they were personally liable for any debts the CC incurred as a direct result of their participation in management. No accounting officer. If the position of accounting officer remained vacant for more than 6 months, any member who was aware of the vacancy and didn't take reasonable steps to fix it could become personally liable for debts incurred during that extended vacancy.
That list really underscores that limited liability came with responsibilities and compliance requirements.
Absolutely. It wasn't a free pass.
Those were specific statutory liabilities. What about situations involving really bad behavior, like outright fraud or recklessness?
That was covered by Section 64, a very powerful tool. If it could be shown that the business of the CC was being carried on recklessly, with gross negligence, or with intent to defraud any person or for any fraudulent purpose, a court could, on application, declare that any person, member or not, who is knowingly a party to carrying on the business in that manner would be personally liable for any or all of the CC's debts, as the court directed.
So knowingly being involved in dodgy dealings meant your personal assets were completely exposed.
Precisely. It was a significant deterrent against abusing the CC structure for fraudulent purposes.
And wasn't there one more catch-all provision, the idea of piercing the corporate veil for gross abuse?
Yes. Section 65. This was the ultimate backstop. If a court found that the incorporation of the CC, or any act performed by it or on its behalf, constituted a gross abuse of the juristic personality of the corporation as a separate entity, the court could declare that the CC was effectively not a separate legal person for the purposes of specific rights, obligations, or liabilities involved in that abuse.
So the court could basically say, forget the CC structure for this particular issue. We're looking straight through to the individuals involved.
That's essentially it.
Right.
It allowed courts to disregard the separate legal entity status and exceptional cases of serious misuse, ensuring the structure couldn't be used as a shield for blatant wrongdoing.
Okay, so liability wasn't absolute. Now, what happened if a CC just couldn't continue for financial or other reasons? How did the winding up process work?
Well, Section 66 was key here. It basically imported large chunks of the company winding up law, mainly from the Old Companies Act of 1973, though solvent liquidations now might fall under the 2008 Act's procedures. The Act cleverly adapted the terminology company meant corporation, shareholder meant member, director generally meant member, and so on. It essentially said, use the existing company liquidation rules, but apply them to the CC context.
So leveraging established procedures, did it distinguish between voluntary winding up and being forced into it?
Yes. Section 67 covered voluntary winding up, usually initiated by the members themselves if they decided to cease trading or if the CC was solvent and they wanted to dissolve it. And Section 69 defined when a CC was deemed unable to pay its debts, triggering potential involuntary winding up by creditors. This could happen if, for example, a creditor was owed money and served a formal demand that went unpaid for 21 days, or if a court judgment against the CC couldn't be satisfied.
Standard insolvency triggers. Now, earlier you mentioned members potentially having to repay money before winding up. Can we revisit that? What if members took out distributions or salaries when the CC was already shaky?
Right. This links back to protecting creditors during insolvency. Section 70 dealt with payments made to members by reason of their membership, like profit distributions, within the 2 years before the winding up commenced. If the CC was wound up and couldn't pay its debts, those payments generally had to be repaid by the member unless the member could prove two things. First, that the payment was made while the CC was solvent, assets exceeded liabilities, and second, that the payment itself didn't cause the CC to become insolvent. Former members could also be caught by this.
Okay, so no stripping assets via distributions on the way down. What about excessive salaries?
Section 71 addressed that. If a CC was being wound up insolvently, the master of the High Court could investigate salaries or other remuneration paid to members, acting as officers or employees, within the 2 years prior. If the master deemed any payment not to be bona fide, in good faith, or not reasonable considering the circumstances, they could order the member to repay the excessive or unreasonable portion.
So you couldn't just pay yourself a massive salary to drain the company before it officially collapsed.
That was the idea. Both sections aim to claw back funds for the benefit of the creditors if members had unfairly benefited shortly before insolvency.
And who managed this whole winding up process?
A liquidator, appointed by the Master of the High Court, Section 74. Their job was to take control of the CC's assets, investigate its affairs, call meetings of members and creditors, report on potential liabilities of members, Section 70, 71, 63, 64, liquidate the assets, and distribute any proceeds according to the legal order of preference, primarily to creditors first.
Was there any way to avoid full liquidation if the CC hit trouble but might still be salvageable?
Yes. Section 72 provided for a composition. A CC facing liquidation could make a written offer of compromise to its creditors. If creditors representing at least 2/3 in both value and number of votes accepted the offer, it could become binding, potentially allowing the CC to continue operating under revised terms rather than being fully wound up.
Interesting. A potential lifeline. Okay, we've covered a lot of ground here, from birth to potential death of a CC. Let's try and distill this. What are the absolute key takeaways for you, the listener, from our deep dive into the Close Corporations Act?
Okay, first and foremost, the close corporation was, and for existing ones still is, a distinct and really quite significant legal entity in South African business law. It was specifically crafted, remember, to offer a simpler structure with that crucial benefit of limited liability, tailor-made for smaller businesses, typically up to 10 individuals.
Right. Simplicity and protection were the goals. Second, it wasn't a free-for-all. The Act laid down clear rules for everything. How you set it up with the founding statement, how you managed it day to day, the importance of keeping information updated, and eventually how it could be dissolved. And as we highlighted, the role of that independent accounting officer was a really interesting feature, acting as a kind of built-in check and balance.
Definitely. And the third key takeaway, maybe the most important practical lesson, is that limited liability, while powerful, was never absolute. As we spent some time on, there were very specific situations, non-compliance with formalities like using the CC name, failing to pay contributions, improper payments, disqualified management, and especially reckless or fraudulent trading or gross abuse, where members could lose that protection and be held personally responsible for the CC's debts.
Yeah, that balance is crucial. Protection for honest entrepreneurs, but accountability for negligence or wrongdoing.
Exactly. It highlights that constant tension in business law. How do you make it easy for legitimate small businesses to thrive while still protecting creditors and the public from misuse?
So stepping back, what does the fact that you can no longer form new CCs tell us? Perhaps about how the legal landscape's priorities have shifted since 1984. How these legal frameworks keep adapting to the needs of commerce, always trying to find that sweet spot between flexibility and robustness. It really makes you think about how business structures evolve. Understanding that CC Act isn't just history, it helps us understand why current laws, like the 2008 Companies Act with its own options for smaller companies, are structured the way they are. What might the next evolution look like for small business entities? Definitely something to ponder.